Okay, I was a physicist. Essentially, I taught physics at the University of Washington Instructional Center for 20 years. I have exposure to information theory, which is now important in physics, through von Neumann information theory, which predates Shannon information theory by a few years. Um, Now, the natural form of analysis of problems in physics is states. So we're talking about quantum mechanical states, the complete set of quantum mechanical states of a system. In physics, before you do anything, you have to analyze you have to first ascertain what the system is going to be and what the surroundings or the environment is going to be in your problem. So if you're doing the entire universe, then there will be no environment. The whole thing will be the system. But that's what cosmologists do. Anybody who does physics in any other application will do something else. Engineers use physics to solve their problems, etc. All right. So the thing that's important is what information is present in the system. Now let's talk about communications theory, the act of providing mind-to-mind transfer of information. That's what communications is after interpretation, after being absorbed by another mind. That's the kind of communications that I'm talking about. That's the only kind of communication that's important in law. Law is published. It's enacted by the legislative body. It's published, and then it's read and interpreted by minds. Okay, now ideally, there should be only one reasonable interpretation of the law. That's usually the case, but it's not always the case. If you come up with a law like Fort Collins City Ordinance 17181, there are literally thousands of possible interpretations. The most reasonable interpretation to make is what's called the textual interpretation, which is, and there's a lot of Supreme Court precedents which says that every word of the law should be applied as to its meaning, and none should be ignored. So that's what you do. You just read it word by word and apply it. That's a textualist interpretation. Now, there's also a legislative interpretation where where a judge, this is the job of the judge, tries to figure out what the hell the legislative body meant when they wrote this piece of shit or whatever. So they have access to internal documents or whatever documents might be provided by either party as discovery and stuff, and they come up with some interpretation. So now, so a law is a written communique to the public in just a string of words and symbols, and that's what it is. Okay, now there's been some legal analysts who think there's a big deal between acts and statuses. There's no big deal. There's no huge differentiation that can be made. So first of all, any law can be written. The only thing that's important about a law is the complete set of information that it transfers to another mind, right? So the complete set of information that's inherent in the communication that provided by the written word, the words of the made law. That's the only thing that's important. So it's completely obvious and reasonable to say that a law that can be written in several ways that has exactly the same information. I mean, you can translate it into different languages, or you can replace words with equivalent meanings if that's carefully done, so that it provides exactly the same information to the public, but it has a different string of words or letters or symbols. Okay, so now let's look at a law which prescribes an act. It makes an act illegal. Now, all you have to do is do one, right? If you have a law which makes it illegal to do a whole bunch of things, like makes a whole bunch of conditions illegal, these conditions can be evaluated as whether they're acts or states of being. So if it's the case that any law which prescribes an act has an equivalent representation in terms of a law which has exactly this, which communicates or disseminates or transmits exactly the same information in terms of not acts, but of changes of state of being, then changes of state of being has the power, at least the power, that form of description has at least the power of the form of description in terms of acts. Now, my claim is that there's a duality here, that you could do one in terms of the other and the other in terms of the first. That there exists equivalent laws with equivalent forms of communication either way. So let's look at a law which prescribes an act. Okay, it is illegal to do X. Okay, so that makes it illegal to have not done X to have done X, right? Makes it illegal to be in the state of not having done X to having done X. It also makes it illegal to be in the state of having done X like n times to having done X n plus 1 times. It also makes it illegal to be in this to have the change of state of being from having done X, not having done X at time t, to having done X at sometime t plus delta t. So any law which prescribes an act can be written as an equivalent law which prescribes a change of state of being. So that's simple and obvious. Now let's look at any law which prescribes a state of being. Well, that one, it involves a little bit of trickiness, but it's not really that difficult. So let's say it's illegal to be Y. All right, that means that it's illegal to not perform the act of removing oneself from Y. So it makes it illegal to not perform the act of changing one's state of being from Y to non-Y, to any non-Y state. So any law which prescribes a state of being mandates or necessitates or compels an act. So by acts in general, I mean acts of omission and acts of commission. They're equivalent in law and they're equivalent to me. An act can be doing something or not doing something. Not doing something is an act as well as doing something, right? So, okay, that's the complete duality there. So when people speak about Robinson as being something special, they're simply wrong. They haven't looked at other laws. There's a bunch of laws out there. There's a law that prescribed states of being, not necessarily statuses. What is a status? A status is a special state of being in terms of it being socially recognized. A status is a socially recognized state of being. Homelessness is a status, despite what half the courts out there say. How do you prove this? You just go to Facebook, which is the largest community that we know of, that I know of. Having a community of like 3 billion people plus. Type the word homeful, type the word homeless right next to each other. One will be misspelled. Take a screenshot of it. Send it to your lawyer. The one which is underlined in red is not socially recognized. The one which is not underlined in red is socially recognized. The one which is underlined in red is homeful. Homeful is not, the community of Facebook does not recognize homeful as a status, but recognizes homeless as a status. Give it to your lawyer. Also tell your lawyer that because status is a socially recognized state of being, that in order to ascertain whether or not status is homelessness is a status, a judge must perform behaviors similar to an experimental physicist rather than a theoretical physicist. This can't be figured out through philosophy. She has to look outside of herself. She doesn't have the power to change or to determine this person's status. She only has the power to ascertain it. It can't be done through internal philosophizing. You have to look externally for evidence, because because the stuff is done by society. This is ascertained by society. And society lies outside her brain. So that's why it's an experimental task to ascertain whether or not homelessness is a status. And we just performed the experiment, right? It's a Godonkin experiment at this point in time. Once you go on Facebook, type out those words, print page, copy to an email, send it to your lawyer. Then your lawyer has it as evidence. Your lawyer can give this can submit this as evidence in your case. And then you have this is a done deal. Homelessness is a status. So, but going to the general theoretical question about the difference between laws which prescribe state of being and acts, a lot of laws prescribe states of being. There's a law in Grisham, Oregon, which makes it illegal to be in the park after 10 p.m. There's a law in Broken Arrow, Oklahoma, makes it illegal to be in the median. There's laws which prescribe do being and be doing and do be doing out there. All you have to do is look. And for a famous legal analyst to say that Robinson is the only law in existence which prescribes a state of being or prescribes a status is ridiculous. Because, I mean, I'm sure there are others out there. There are plenty of others which prescribe states of being. Anyway, have a good day. That's about all I wanted to say. Bye.